this. So welcome everybody. I'm Lyric Winnick. I'm the BCC PTSA president. I'm here with my dog who's usually here for Zoom. So she's joined us yet again. And I'm very happy to have all of you here tonight. We are so fortunate. This is a peer parent presentation, and I'm going to turn it over to Erin Horkhart, our organizer for this evening. And thank you so much for joining. And how did anybody think that we would all be parents of young adults? I don't know. I don't feel quite old enough, but I guess I really am. All right. Thanks so much, Erin. I'm going to suggest that everybody, I'm going to spotlight our speakers. You can also, as they start presenting, you can also choose to just do view in your speakers to have it work. So anyway, but thank you very much.
Okay, thank you, Lyric. I have to say I somewhat selfishly organized this, or planned to organize it, because my oldest turned 18 last week. So it's perfect timing for me. And I know that both Lisa and Catherine have presented to BCC in person before, but I thought it's been a couple years. I remembered when my now senior was a freshman, or maybe sophomore, seeing this email go around the listserv and thought, I need help. So I figured other parents were feeling the same way. So I want to just quickly introduce our two speakers who are very gracious to quickly accept our invitation to come back to BCC and speak to parents once again for an evening quick update on what we all need to think about as our kids turn to adults. And I already got like the email from the Privia accounts for my now 18-year-old saying I need to log in and do something. So hoping to learn tonight what it is I need to do. But I want to again say that I'm thrilled to welcome both Kate McQueen and Lisa Seltzer-Becker, both principal attorneys at Offutt Kerman. Both have been practicing family law in Maryland and DC for years. Lisa handles a variety of education-related matters for middle, high school, and college students, including disciplinary, special education, bullying, and academic and sexual misconduct cases. Tonight, she'll focus on higher education, student discipline, and disability issues. Kate focuses her practice on family law issues, including divorce, custody and visitation, child support, adoption, and guardianships. And Kate will focus on power of attorney and guardianship issues tonight. Hopefully, I wanted to just do a brief bio for both of them, and I know that they'll kick off with a little bit more information and then launch into their presentation. So thank you both for joining us, and thanks to all the parents that have come out tonight as well.
Thanks very much. Thanks for having us. I'm Kate McQueen, and let me just get this. I have a screen. There we go. I'm Kate McQueen. I'm here with my law partner, Lisa Becker. He'll talk to you in just a moment. We're both, like Erin said, we're both attorneys at Offutt Kerman in Bethesda. We practice family law, and I do guardianship work as well, and Lisa does education law. We're here to talk to you about what to do when your child turns 18, things you need to think about, and things you need to think about when your child goes to college. We're not here to scare you. At least I'm not. Lisa's presentation may scare you a little bit. I listened to it the last time we gave this presentation 2 years ago in person at BCC, and I was a little scared. I'm just kidding. But we want to thank the PTSA for having us. I know you're all super excited to have a Zoom call at 7 p.m. on a Wednesday. I know I'm probably having a little Zoom fatigue. All of our court hearings are on Zoom now, our client meetings, and it's just getting a little old a year into this, and I'm sure you're all feeling the same way. So thank you for taking some time on Wednesday evening to listen to us. I'm going to try not to have any kind of cat filter on, or multitask by performing surgery or any of those Zoom faux pas. This is the fourth year I've given this presentation, and I have a son who's a junior at Walter Johnson, and so this is getting a little more relevant to me every year I do this presentation. And Lisa also has two boys who are, I think one's in college and one's in high school still. Yeah. And so we are in the same boat as you guys are. But as the program title says, yikes, a lot of stuff to think about and things you probably don't realize because we all view our children as still children. But when they turn 18, it has a lot of implications legally that you may not be aware of. I certainly don't look at my son as about to become an adult when I'm still doing his laundry and fixing him breakfast and all of those things. But I'm going to tell you a little bit about kind of Maryland law And it's important to know that a lot of these things are state law specific. And so what you're going to want to think about as your child heads up to college or to another state or another country, perhaps, is that the law of each state differs in terms of what documents you need, what kind of authorizations you need. And so I'm going to talk about Maryland law, and so it might not be exactly the same in the state or whatever location your child is going to. So when your child turns 18 in Maryland, he's an adult, he or she is an adult. And so as a result, oh, sorry, let me share my screen. I do have a presentation, PowerPoint. Let's see. See if I can just do the presentation piece. I did this and now I'm not sure how to do it without the, slideshow, here we go. All right. So when your child turns 18, he or she's no longer a minor, the decisions that you've been making for him or her are now in your child's hands, including educational decisions, financial decisions, and medical decisions. And included with that is the right to decide who can have information about those educational, financial, and medical issues. So as the parent, once your child turns 18, you're no longer entitled to those as a matter of right. As a parent, if you don't have authorization to receive information, you can always give information, and that's just something to kind of keep in the back of your head. But there are also things to think about in terms of divorce. When your child turns 18, typically that, in Maryland at least, that means that child support will be ending unless your child's still in high school, and then child support will terminate when he or she graduates from high school. A person who's 18 has the capacity to contract, meaning that they can sign a contract and be liable for it, and whoever they contract with can sue them if they don't pay. A person who's 18 can open bank accounts, and if you want to go into the bank and get information about your child's account, and your child's over the age of 18, you have to give a power of attorney to, your child has to give a power of attorney to you, or the bank account has to be jointly titled with you. A parent can only make financial decisions for a child over the age of 18 under certain circumstances. That's typically either as a financial agent under a power of attorney or a guardianship order that appoints the parent as guardian for the child. Every parent is the natural guardian of their child when they're under the age of 18. And unless there are some very rare circumstances where a parent may need to be appointed by the court as guardian for their child if they're under the age of 18, but typically that's not the case. If your child is over the age of 18 and is able to make decisions, your child can sign a power of attorney. If your child is over the age of 18 and not able to make a decision because of either an injury or an illness or some condition that has been present throughout life, such as a cognitive disability, sometimes severe autism, sometimes there are conditions that your child has that means that your child needs help making decisions, but does not have the capacity to sign a power of attorney. And in that case, the parent needs to petition the court for guardianship. And then the court order for guardianship will give the parent the power that the parent needs to make either financial decisions for the child or personal decisions for the child, meaning medical treatment, where the child's going to live, sometimes educational decisions, those type of things. Just looking at this slide that's on the screen now, the third bullet there goes back to what I was talking about previously, in that a parent can have access to a bank account for a child who's over the age of 18 if they're titled on the account, or if the account is titled in the name of the trust and the parent is trustee for the child. Educational decision-making, a child who's over the age of 18 makes their own educational decisions, and the child's educational information is protected typically under FERPA. There are forms that your child can sign that the school will have to give you authorization to receive that information. But it's not just a matter of right, even if you're paying the child's tuition, your child's going to need to sign some forms to give you access to that information. Medical decision-making. Once your child turns 18, you're not authorized to receive your child's health information or make medical decisions for your child, except under certain circumstances. One is your child has signed a medical directive, which is the same thing as a power of attorney, but it's just a different name. A power of attorney typically deals with financial decisions. Some people call it a financial power of attorney or a medical power of attorney. But typically the medical decision-making piece is going to be called a medical directive or sometimes an advanced directive. But the child can sign one of those documents naming a parent or someone else who might be appropriate and over the age of 18 to make healthcare decisions for them. And sometimes in that document, the child might kind of put forth their wishes for if something were to happen to them. The second way a parent can make medical decisions for a child is if the parent has been appointed as guardian of person for the child. States use different terms for guardianship. In Maryland, it's called guardian of the person when you make personal decisions for a child, like medical decisions, educational decisions, where the child's going to live. And then financial decisions is called guardian of the property. Other states use different terms. For instance, in DC or Virginia, the financial decision-making is called conservatorship. So the terms are different, but they mean pretty much the same thing. The third category where a parent can make medical decisions for a child over the age of 18 is if the situation fits within the Maryland Surrogate Decision-Making Act. And that's if the adult child is unable to make decisions for themselves, and in the hospital, the law gives certain categories of people the right to make decisions for a person who needs help making decisions. And it's particularly helpful in emergency situations. So, there are many, many people who get into a situation where, a family member has an accident or, sudden illness and it winds up in the hospital. And even if there's not a power of attorney, there is a mechanism in Maryland law that allows for, after two doctors certify that the person's not able to make those decisions, that a family member or a close friend, the law provides categories and priorities for people to make those decisions if they have to. So you don't have to go to court right away if there's an emergency and medical decisions need to be made. So in terms of what you need to do, or what you need to at least think about when your child's turning 18, is you can ask your child to consider signing a power of attorney and medical directive, naming somebody to make decisions for him or her. If you and your spouse are on the same page, whether you're married or not married, if you are on the same page and able to make decisions together, it's helpful to name two people or one person and a successor. And it's often, the parents are typically the person who's going to be named by a child who's just turned 18 or, in their late teens or early 20s. One thing to also consider is an advanced directive for mental health treatment. I get a lot of calls from parents who have kids in their early 20s who have mental health issues. And, oftentimes the issues arise or worsen once the child goes off to college or in their early 20s. And it's an advanced directive for mental health treatment is not a perfect solution. Mental health issues and making decisions for someone else to receive mental health treatment is a very tricky situation because the law balances the rights of somebody with mental health issues not to receive treatment under most circumstances versus the authority of somebody named in a mental health directive to make decisions for somebody. And so if your child has mental health issues and you want to talk to them about this, I think it's definitely helpful to have something in writing talking about it. The child can express his or her preferences about certain types of treatment, medication, hospitalization, all of those things. But if your child gets to a point where he or she is resisting treatment, needs treatment but is resisting it because he or she lacks insight because of a mental health issue, an advance directive is not going to get you as far as you need. But it is helpful in terms of getting information for somebody. And it is helpful if the child is cooperating in order to help that child make decisions. But if the child, resists treatment and emphatically refuses it, you're not going to be able to make involuntarily commit a child using an advance directive for mental health treatment. Just something to be aware of. In order to sign a power of attorney or medical directive, the person signing the document has to have capacity to do so. And like I said, if your child is attending college in a different state, states have different requirements for what the power of attorney has to say and how it has to be executed. And so it's important if your child's going to a different state that you think about whether, if you use a Maryland form, whether it's going to be enforceable in the other state. And oftentimes, Maryland has a form, statutory form power of attorney that provides that institutions in Maryland have to accept this document. And so if your child's going to a different state, sometimes it's easier to have them do something that you know has to be accepted where they're going, because trying to argue with a bank's legal department is just really difficult. And sometimes it's easier just to do what you think they're going to want. Your child's school may also have consent forms that'll be helpful, especially in terms of medical information, and they'll definitely have educational forms that you're going to want them to sign. And so, like I said, for financial decision making, the document's a durable general power of attorney, and you're going to name somebody, or your child's going to name somebody to make decisions for him or her. There's two types of powers of attorney. One is effective upon the person's disability, and one is effective upon the signing. And it's easier to have it be effective upon the signing because then you don't have to prove that someone is disabled. Some documents say that you have to have two medical opinions from doctors saying that their person is disabled before the authority under the power of attorney kicks in, and that can just be a little cumbersome. We kind of talked about this stuff. Okay, so these are some links you can look at for Maryland, at least. And any attorney is going to tell you should go to your own attorney and have somebody draft documents for you that are specific to your situation. But it is helpful to look at these forms because they can help you start the conversation. The Maryland Attorney General has forms for a power of attorney and a medical directive. And so there's a link here on this PowerPoint. The page we're looking at now at the bottom has the form for the statutory power of attorney. And like I said, this form has to be accepted in Maryland as long as it's properly executed. And so that's a helpful document to have. It may not cover everything that you want a power of attorney to be able to do. So like I said, you should probably go to an attorney and just kind of talk about exactly what you want and see if this form is all that you need. But it's a good starting point. And then we have information about advanced directives, this link at the top of the page here. And then this talks about the mental health treatment that I talked about. The Maryland Department of, can't remember if it's health, but this link at the bottom of this page has information about decision-making for mental health, and it has some really good discussion topics. So if that's something that's applicable to you or your family, I'd recommend you take a look at that because it's a helpful discussion to have, especially if your child's going to be, going off and having more, going off further away, and you're not going to have as much contact with him or her and not be able to check in as much. So like I talked about, for medical decisions, sometimes the Surrogate Decision-Making Act will apply, and then you don't need to seek guardianship of the person, especially for younger people, where if it's an illness and the person is going to recover and it's just a finite period of time where somebody needs to be able to make decisions for them, the Surrogate Decision-Making Act may help. But if the disability or illness is longer lasting, then you may need to seek guardianship of the person to make medical decisions, and you would need to seek guardianship of the property to make financial decisions. this talks a little bit about the process for obtaining guardianship. I'm not going to read these slides to you, but the important thing to know about for guardianship of a person who's over the age of 18 is that it's a court process. It always, in Maryland, it always provides for an attorney to be appointed for the person who's alleged to need a guardian. So if you're in the situation where you have a child who has turned 18 and you know that your child's not going to be able to make decisions for himself or herself, you're going to have to file for guardianship. You just need to be aware that the process involves the appointment of an attorney for your child to talk to your child and say, do you agree with the guardianship? And do you agree with, your parents or whomever has filed the petition acting as your guardian? And in my experience, in most cases, the child says, yes, I agree. But the law in Maryland is that whatever the person tells their attorney, as long as they're able to share their thoughts, regardless of whether their court-appointed attorney agrees or not, that attorney has to advocate for that position in court. And so if your child, if you know your child may have an issue with it, you just need to be prepared for the process that the court will hold an evidentiary hearing on whether your child needs a guardian and whether you're the appropriate guardian for your child. It's not an awful process in most cases, but it is a legal process. In some cases, it can't be avoided. If your child has had a long-lasting condition and would have never had the capacity to execute a power of attorney, then you're not going to be able to avoid guardianship, and you just, have to do it. But hopefully, that's not the case, and you can just ask your child to execute a power of attorney. Another thing to think about as your child turns 18 is whether you've done the planning that you need to do. And I should listen to myself here because I have planning I need to do. But you want to make sure that you have an updated and valid power of attorney and medical directive. I've certainly also had situations where, young adult children have to make decisions for their parents that if they don't have a valid medical directive or instructions about what their parents' wishes might be, and there's not a spouse who can, help in that process, it's not a situation you want your young adult children to be in. And it's not a situation where you want your young adult children to have to go to court and get guardianship for you if you don't have a power of attorney and medical directive naming people to make those decisions for you. It's not a good place to put your kids in. You want to make sure you have life insurance, of course. And another thing to think about is that you want to make sure that you have a trust, that your life insurance beneficiary is your trust, so that your kids don't receive whatever the death benefit would be, 500,000, $1 million, whatever it is, at the age of 19, and decide to throw a great big party. Not that they would do that, but that's not really the age when you want large sums of money to be falling into the hands of your children. And so you want to make sure that you've created a trust for your children, name somebody you trust to act as trustee. And if you have a child who has a disability and needs government benefits, you want to make sure that the trust is properly prepared to protect your child's government benefits so that they don't lose eligibility if your child becomes a beneficiary or receives life insurance or any other assets if you die. And that's a special needs trust. You want to make sure that if you think your child is going to have a long-lasting condition that's going to prevent your child from working or mean that your child is going to rely on government benefits, whether it's supplemental security income or whether it's whatever other benefits, Medicaid, anything like that, those require low levels of assets. And if you do the right planning for your assets, if your child inherits them, you can make sure that your child retains eligibility for those benefits and that their needs can be supplemented by the money in the trust by someone that you trust. Another thing to think about is your beneficiary designations. If you are divorced, you want to make sure you update those beneficiary designations. I certainly have had clients who have been late doing that. These are just other things to think about, you know, as your children get older and you kind of think, you know, we never know what's going to happen. And so we want to make sure our kids are well protected. And so, you know, for life insurance, you want to make sure that, you know, if your child attends private school or college, you want to make sure that there's a source to pay that cost. And then talking about your family members receiving government benefits, that gets back to the special needs trust issue. All right, more things to think about and scare you. But mainly just my ultimate recommendation is you know, my practice area deals with kind of families at every stage and dealing with very difficult issues. And I see families who are going through very difficult times and dealing with arguments, and, you know, they're not often able to, they often are disagreeing about important issues that perhaps could have been addressed previously with discussions and proper planning, and most particularly in cases where children are kind of arguing about what to do about mom or dad, whether it's money or medical treatment or that type of thing. That, you know, in my guardianship cases, that happens quite a bit. And you often think if this parent had just done the proper planning and had the discussions with their children, maybe they could have all gotten on the same page and we wouldn't be here now. So it's just, you know, trying to do all the preventative things you can do. All right, so that's it for me. My email address is here if you have any questions, and I think Lyric and Aaron, I think, are receiving comments or questions as well. So thanks very much.
Hello, I'm Lisa Becker, and thank you to Aaron and Lyric, and thank you for everyone listening tonight, and thank you to Kate, who brought me into this about 2 years ago to go to BCC and do our presentation. I am going to try to show my PowerPoint now. It'll just take me a moment. Okay. Kate, I'm not finding slideshow for some reason. I don't know why.
I think if you look up at the top of your screen.
Yeah. Oh, thank you. Okay. All right. So as Kate said, I practice family law, including divorce and custody and all that good stuff. And I also do education. And in my education practice, I do a lot of disciplinary work. Tonight is really focused on the college stuff. And no, I'm not here to scare everybody. But there's a lot of pitfalls that I think it's good for the kids as well as their parents to be aware of. And first I'm going to talk about Title IX. I'm not sure if everyone's aware of what that is. It's the federal law. It was enacted in 1972. It ensures that students are not discriminated against on the basis of sex. And the law, the main part of the law is right there. For a long time, the application of this law, I think people thought of it anyway, was how it was applied to equality between genders, sexes in sports. You know, there's a boys sports team, there should be a girls sports team. But in the last 20 years or so, it's also applied to sexual misconduct in the university setting.
Lisa, are you
Mm.
sharing your screen?
I thought I am, but if I'm not, I'm sorry. Thank you.
Should be right on the bottom of the Zoom screen. You should see kind of in the middle next to chat. It says share
Okay.
screen.
I apologize for my Zoom ineptness here. Okay. I'm trying to make this work. Okay, I'm going to, I think I got it now. Can everyone see this screen? It
Yes.
says Title IX on a chalkboard. Okay. So all right. Thanks, Catherine. So it provides the main part of the law, and it also says that it applies to sexual misconduct and harassment, as well as, you know, equality in athletics. In August of 2020, there are regulations for Title IX that went into effect. And without getting into a lot of the nitty-gritty of the law, there were two main changes that I think some people were upset about, and they were controversial. I actually think that they were good changes, but with the changes are, namely, it used to be that a college or a university could hold an investigation of accusations of sexual misconduct of a student, and the same person who was doing the investigation would also be the decider of, they don't call it guilt, but that's what it is, it's guilt. They call it responsibility. And this is not a criminal finding, but it can get the person accused expelled or suspended. And obviously, someone who commits sexual assault should be expelled. The problem is that in some of these cases, the courts were finding that the process did not include due process, and certain kids were being accused of things. There was very little or very shabby investigation done. And they were being found responsible and expelled, and they had, you know, that was it. At the same time, there was a lot of controversy because there were a lot of mostly female students who felt that colleges were ignoring their complaints about sexual assault and that they weren't being heard, and or, you know, they were being reported and ignored, or that the process wasn't being fair to them. So on both sides, there was a lot of problems with the college process, and some of those problems persist, and the regulations are a bit, like I said, they're controversial, but one of them is that the cross-examination is available to both the complainant and the accused. Some people find that upsetting or traumatic. It does tend to make it a more fair process, but it also can make it a more upsetting process. The idea that the investigator is also the decider of guilt or responsibility is no longer permitted, and that's good, because that really was not helpful to anybody. And there's also part of these regulations that schools have to provide certain services for complainants. If you say you've been assaulted, the school has to do certain things for you, and give you certain information that you're entitled to. I don't want to spend too much time on Title IX. It is out there in the news, but that's sort of the update on the law. And it's important to remember that the college process for Title IX is completely separate from any criminal charges. So often what a student might make a complaint, a Title IX complaint about in college, sometimes was an upsetting event, which was not appropriate, but wouldn't necessarily be a crime under the law in that state where they live or where they're going to college. That doesn't mean it's not a violation of a student code. And that is, I think a lot of people don't realize that. So student codes, both with regard to sexual misconduct and just regular conduct or misconduct, are far, far more broad than what the law, the criminal law says that you can or can't do. That's not supposed to be scary. It's just the way it is. And private colleges in particular are allowed to make the rules they want to make. And you're essentially, if you choose to go to that college, you're sort of agreeing that, I'm okay with these rules. You may not know all the rules, but essentially you're agreeing to abide by them. So, but while a college, a public or private university, has student codes that are far more expansive than the criminal code, if a student is charged with a criminal matter, let's say drunk driving or theft or something, then that is generally also a violation of the student code. It could be something like a citation for smoking marijuana. It may not be a criminal matter in that state, but it's a citation. That is usually also a student code violation. And there is a lot of sharing of information I've seen between the local police and the universities. Now, if a student, again, is accused of a student conduct violation, of a university conduct violation, the process is completely separate from any criminal process. And it's an informal process that the school has for this student. I represent students in these conduct disciplinary matters, both Title IX and non-sexual misconduct matters. It's important, a couple things that parents should know. If a student is accused of anything at school, it could be something rather benign. It sounds rather innocuous. Oh, I took my mask off in the dining hall or something. But they're given a charge. They're given a notice of violation. They should call you. They should call their parents. And this really kind of dovetails into what Catherine was saying. They don't have to legally, but they really should, because the penalties, the sanctions can be rather significant, and I'll get to that in a moment. There's a slide that talks about NCOs. Those are no conduct orders. That is something that the school will implement if students have sexually harassed, stolen from each other, have gotten into conflicts. And that needs to be, that's just something that the school can implement upon accusations without any sort of finding of responsibility or not. Sanctions for misconduct, can range from reprimands, writing a paper, what did you learn about this experience, much like a student might get, in high school, to being expelled. And lately, I have seen some pretty unusual circumstance, and I'll explain what that means. COVID has surprisingly created a whole new area of discipline, and that is kids who go to a party, have more than 4 or 5 people in their dorm room, take off a mask while they're at such a get together. And every college is handling it a little bit differently, but I had 2 calls today. I'd say roughly I've averaged, I've lost track. I get calls frequently in the past year from, especially since the fall started, from parents whose kids went to school, and every single time I hear, and they're great kids and they do really well in school, because what I'm about to tell you has nothing to do with them being great kids and has nothing to do with them being smart and studious. They walked into a party. It could be on campus, it could be off campus. And someone heard the music and called the cops, whether it's campus cops or local, local police. And their being at this party was a violation of local ordinances regarding COVID and a violation of the school code regarding COVID. So I can't stress this enough. And I have a son in college, and I've had the same conversation. And not that he listens to me any more than anybody else is going to listen to their parents, but if they tell you to wear a mask, wear a mask. They tell you don't have more than 4 people in your dorm room, or whatever the rule is, don't have more people in your dorm room than you're allowed to. A lot of what happens is that, it's what I've seen anyway, the students kind of out each other. So if someone doesn't like you or feels offended that they didn't get invited to your improper get together, they will call the school, or they will take a screenshot of an invite or something. So there's all this kind of craziness going on. Schools have ranged significantly in how they deal with this. Some of the smaller schools, I think, are a little bit more reasonable in their reaction. Some of the larger schools have suspended kids for COVID violations. And my guess is the larger the school, the more they have to worry about COVID spreading, and they don't want it to be unsafe. Okay, so what kind of legal level of justice do colleges owe the students? If it's a public school, theoretically, they owe them due process, certainly under Title IX, and to expel them or suspend them, generally speaking, for any disciplinary matter. A private college, now that Title IX, now that there's been a lot of federal cases, also owes a duty of due process. But federal colleges can also make their own very restrictive rules. And you can sue a private college for breach of contract, theoretically, in some places. Some places it works, some places it doesn't. Obviously, nobody wants to send their kids to school thinking that they're going to sue them. I only mention this because the remedy for being kicked out of school is limited, and you don't want to have to go there. It's expensive, it's limited. It's obviously better to avoid getting in trouble in the first place, or getting, doing whatever it is that the kids are doing to get suspended. But sometimes, like I said, in the last year, we're living in this sort of crazy time. Some of what they've done is not, we're not talking about sexual misconduct or selling drugs or anything of that nature. We're talking about taking off a mask or having too many people in a room. So, and if anyone's kids get, a notice of violation, it is so much smarter to call a lawyer earlier in the process than later, because there's less the lawyer can do later than earlier. The earlier it is, the more we can help. This may seem obvious, but how do students end up accused of sexual misconduct? Well, someone commits sexual assault. They commit a crime. Sometimes there's alcohol use by one or more of them, and they have very, 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 very different memories of what happened, or neither one really remembers. And obviously, if someone is incapacitated, it's not legal to be having sex with them. College, like I say, the college codes are far more broad than the law as to what is allowed. So coercion in many schools is considered sexual assault. Students on the autism spectrum tend to get a little bit more caught up in that because communication skills are just not as well developed. So, high functioning students on the autism spectrum that haven't had a lot of experience with dating sometimes have gotten accused of harassing someone. I've seen that. Poor communication skills and poor emotional intelligence also. Sometimes it's just someone making an accusation that has no basis in reality, but that doesn't happen. That's not the majority. There is a higher rate of students who are African-American who get accused. And the other thing that happens is sometimes resident advisors and professors are mandatory reporters, and someone will be talking about an experience they had that they didn't mean necessarily to make any accusation of, but was upsetting. And now they didn't realize it, but they've shared this experience with a mandatory reporter, which may ultimately be helpful to the safety of the university. It's just that the person sharing this wasn't necessarily intending on making a complaint. So there's that. Okay. Prevention, and this is not supposed to be cute, and this is really more for the kids, and they all get this training way more advanced than what I'm doing is, but everyone should follow the school's requirement for clear verbal consent, express consent. They shouldn't have sex with someone that they think is impaired. They shouldn't have sex if they're impaired. And if they have a doubt, we're not really sure, then just don't do it. It's just not worth the risk. It's not worth it, and it's probably not a good thing for your relationship with this person. There's just no reason to do it. Okay. What to do if accused? And I hope this is no one, I certainly hope this does not apply to anyone in the audience, but this was supposed to be, and I apologize for this, a link. I'm not sure that the link is exactly working, and I can certainly get you the link, but if you look at my profile, there's a list of 10 do's and don'ts. if one is accused of sexual misconduct. Okay, academic dishonesty. Again, COVID has really ratcheted up academic dishonesty accusations. Why? Because everyone's taking their exams at home. But even before COVID, I noticed something. I noticed from talking to my kids and their friends and the clients I've had, I hear, well, everyone was working in a group. Everyone was doing this. And it sounds like things that teenagers say. And I think to a large extent, in high school, if everyone is doing something, working together in groups, I'd be a little surprised if the whole class is going to be charged with cheating. I think that the school's more likely to look at that as a communication problem if, in fact, the teacher didn't want everyone to be working in groups. But not in college. Not knowing the rule is not a defense. The kids are expected to know the rules. They're expected to look at the syllabus. They're expected to, if they're in doubt, again, if you're in doubt, don't do it. Don't assume, well, I'm in doubt, so I didn't know any better, it's okay. That's just not how it works in college. There's a lot of codes and policies, and the kids, they're 18 years old, generally speaking, when they go, and they are expected to not to memorize them, but to be responsible for all the rules in them. Okay, so COVID cheating. This is new and fun. I hear about this a lot now. From what I hear, it's pretty rampant, which is not good. But so are the accusations of it. And what some professors have been doing lately is putting out trap questions into exams, okay? Meaning, maybe I should back up and explain what Chegg is. This is nothing against Chegg, which is a very big company which provides tutoring services. Some kids use it to cheat, okay? And from what I've heard, they also use Quizlet to cheat in high school. I'm not here to condone or condemn either of these businesses, just letting you know that Chegg tends to be a big thing in college. So what some professors will do is, knowing that the kids will take an exam question with the right answer and post it on Chegg or sometimes on Google or another online resource, they'll come up with a fake question with a fake answer, so that the kid will then put it on there, and all the other kids in the class who have the section after that will then find it and put it in the rank and put in the same wrong answer. And Chegg, when you sign up to use it, has a I guess it's a fine print disclaimer, or you're signing your agreement that if you're using it, you are allowing Chegg to share your personal information, not your credit card information, but your email, your IP address, and everything that you looked at on Chegg with the professor, if a professor or your school administration asks. I shouldn't say most, many students don't seem to realize that. So what happens is, professor has 800 kids on like asynchronous lecture class. So, and then they all have to do their at-home exam, and there's a lot of chatter about, oh, well, you can go on Chegg and get the questions, whatever, and they fall trap to the trap question, and then they all put the stupid answer down, the wrong answer, and TEG will provide the school with a record of, and I've seen it, exactly the time that they were looking at the question they were looking at, and their email address and their IP address of the location of their computer. So don't do it. I mean, I don't know how strongly I can, no one should be cheating anyway, but it's just really stupid. The other thing that some schools are using, although I haven't had a case of this, is like eyeball tracking software. So that while you're taking the exam, you're being watched to see, how many times you look down or do you look over to see if you're cheating. They're not perfect, and I think sometimes they catch people doing things that they really aren't doing anything wrong, but I'm just saying it's out there. Okay. So what happens? What are the sanctions if you're found responsible for cheating or academic misconduct, whatever you want to call it, in college? Some schools, like University of Maryland, use what's called an XF. An XF means you cheated. It's not just an F, it's an XF, and that's what it means. If you get an XF, often it has very negative consequences for internships, leadership positions, being, in a fraternity or sorority, scholarships, athletics, and it doesn't mean that you won't get a job or get into graduate school, but it certainly doesn't look good. And so people want to avoid an XF, but it's not as bad as being suspended, obviously. It's just something that you obviously want to avoid. And I've seen students say, and I really do believe that they were being honest, say, I just didn't know. I didn't know it was a problem because everybody was working on the project together. And it's the kind of thing that a high school kid would say. And so my point is simply that they have to be aware, and I don't think they always are, that the stakes are different and the way that they're viewed is different in college. But again, I'm not here to scare anyone, just to make that point. Okay. Student conduct violations that are not sexual misconduct. I kind of talked about this. School code governs discipline, including drugs, drinking, theft, weapons, and minor infractions. And generally, I get called for minor silly stuff when it's not sexual misconduct, but COVID is not considered minor, even if the action sounds pretty innocuous. I think I already went over, if you're given a citation off campus, this can also be a student conduct violation. Recourse if accused. If it's you have to go through the school process. Usually colleges will give you the opportunity, it depends on the school, they're all a little different, but they'll give you the opportunity to either have like a one-on-one meeting or a more elaborate honor review or board. Every school calls them something different, but in other words, it's usually like a big conference room where you have a number of professors, students, different schools have different makeups, but and you argue your case, but you're not always entitled to a lawyer. In fact, a lot of schools don't allow you to have a lawyer, or you can have a lawyer, the lawyer has to sit there and not say anything, just to write notes. So it's just not a process anybody wants to be in. And then if the student is found responsible, they have usually a limited right of appeal. What happens if they lose the appeal? Well, if it's a public university and they are and it's not an academic matter, but it's school conduct other than Title IX. I think the school's subject to due process, and there could be literally a federal case made. That's hardly something most people want to do, but it may be better than being expelled, certainly. If it's a private school, then basically they're left with contract claims. In some states that's viable, in some states it's not so viable. It's not so easy to make. So you really, what I've heard sometimes are parents say, well, we didn't want to get lawyers involved at the school level. We wanted to see what happened if we could beat it. And to that I say, no, that's the earlier an attorney gets in, the better. Even if they can't talk at the hearing, they can advise a student on what to do and what not to do. They might be able to write letters to the school. They might be able to get certain evidence that the student wouldn't know to get. There's just more options. You don't want to get to the point where you're left with suing the school if you can do something earlier. Okay. Disability accommodations. A lot of times students have 504s and IEPs. These do not just transfer automatically to universities. First of all, IEPs are not really, the IDEA does not apply to higher education. So you don't get an IEP, okay? 504 of the Rehabilitation Act does apply, but it's not that you have a 504 plan the way you do in high school. You need to request the accommodations. And one thing that I'm sure anyone who has a senior or a junior is probably seeing, colleges really want, especially when the kids are there, but it starts even a little bit before that. They really want the kids to advocate for themselves, okay? So obviously you want to help them, but, and this really goes to what Catherine was saying, if they have a 504 for, ADHD or a learning disability or, autism spectrum issues, they need to ask, you can help them, but they need to ask the school for accommodations. So you need to figure out, is it the Office of Student Disabilities? There's usually a department that is called something to that effect. And you need to fill out whatever paperwork is required to do it. Often colleges, often colleges want a psych educational report no older than the last 3 years to give accommodations or some kind of medical support. But it depends on the college, and everyone's going to be different. But you should definitely get your, if you think your kid needs that, you definitely have to get your ducks lined up so that you have all that information and it's not stale when they go to college. Unlike in high school or middle school, K through 12, there's no obligation on a college's part to identify a disability of any sort. And I have seen cases where a couple cases where a student was thinking, oh, I don't really need it. I'm past that. Or they had a traumatic brain injury and they really needed accommodations, okay? And they didn't ask for it. And when they asked for it, they had already failed an exam. Well, unlike in high school where you might be able to argue, well, you knew this kid was having a problem. And under the law, you had an obligation to, ask the parents if they wanted an IEP or 504. There's no obligation. So you really have to advocate for yourself and you have to advocate smartly for yourself. And that means if you think you might need it, or you think your child might need it, ask for it and let the school know. Even if they decline it, it's important that you tell them that you think they need it. So in case anything does happen, at least you have a record of having made the request. Okay. It's just my contact information. And that really concludes it. And I just want to thank Erin and Lyric for having me do this.
Great. Thank you so much. Do you have time to stay for a couple of quick questions? I think there are a couple of questions that people wanted to ask. So I'm going to see if they come into me. And I will just check on that. I guess what are the just run through one more time, if you don't mind, the central documents that parents should make sure that they get for their kids, that you need a power of attorney for financial, for medical, but what do you need?
Sure. So there's decision making and there's access to information. So if you want to be able to make sure that you're able to make decisions, if your adult child is unable to, you're going to need a power of attorney for the financial piece, and what's often called a medical directive, sometimes called a medical power of attorney for the medical piece. If it's just access to information, there are a lot of places have releases you can sign. So like if you know where your child's going to be getting medical treatment, for instance, the health center for the school, they probably have a HIPAA release you can sign. And I'm sure the school will have a FERPA release for the educational records. So there's kind of two steps there. Do you want just the information, or do you want decision-making, which includes the ability that, if you had a power of attorney, you're going to be able to get information and make decisions based on that information. Whereas like a HIPAA release is only going to give you the information.
All right. Is there anything else? Lisa, how much do the colleges, you talked about needing to know all the rules in advance. How good, or what's the range of the colleges going through and explaining the rule book, like during freshman orientation or whatever? Do the colleges generally do a good job, or is the burden on the students to know things from COVID rules to academic integrity rules to, sort of, shall we call it party/extracurricular rules?
So when I say know the rules, I don't know if you noticed one of those slides had somebody with a stack of documents. If you go into any college student conduct policies and procedures, it's Byzantine, because it's very confusing. It's complicated sometimes for the lawyers to look at it and figure out, well, which rule applies. Sometimes the rules are internally inconsistent, and there's a lot of them. Nobody is telling the kids, oh, let's sit down and dig deep into, section 4/5. They're not doing that. What they do is, most schools that I'm aware of, they have these modules. It's part of orientation usually, or in their first semester, that they have to learn about consent. I think most kids already know it. But that's the Title IX, the what not to do, the sexual misconduct stuff. It's not taught from, we have rules against it, but as you don't do this stuff. COVID is interesting, and all of this is very new with COVID. What I've seen is that the messaging sometimes on COVID is off, and that's because events overtake the messages. So one week the policy is you can have 4 people in the room, and next week it's, well now we're back to you can't. And it's confusing to the adults. It's really confusing to 18, 19-year-olds. I mean, I can tell you, I don't want to say the school, but they put out contradictory information. Well, I don't believe it was intentional. I believe it was just hard to make it clear, okay, what you're allowed to do and what you're not allowed to do. So a 19-year-old I know emailed the school, are you saying I'm allowed to do X? And they came back and said, yeah, we think that's right. I mean, it is confusing when it comes to COVID, and there's a fluidity to it. You know, we all know that one day we can do this and next day the restaurant isn't open or it's open later. So no, they're not really going over any rules except maybe sexual misconduct and putting up posters and sending out emails to remind them about mask wearing and party gathering. But that's pretty much it. So.
Super helpful. One more question. Do you need a power of attorney if you have a joint bank account? I mean, is it basically a good idea to have a power of attorney for, you know, some unknown event that could happen, so you're not trying to get it retroactively? Or, you know, if you've sort of lined up your other dominoes, are you okay?
I would say a power of attorney is a good thing to have, and a power of attorney is going to cover broad categories of things that you have power over. That would include bank accounts. A joint bank account, if you are jointly titled on it, it's, you know, you're going to be able to access it. It means you have ownership of it as well. And so then if your child overdrafts the account, you know, you're going to be on the hook for that. So there's pluses and minuses for that. But you know, of course, I'm the lawyer, but I'm going to tell you that I think it's a better idea to have a power of attorney.
Are these documents, do they last forever, or are they do they sunset? Are they time limited?
They are not time limited. The only thing that can happen, and you know, is that laws change, and so you may have, but this is over the course of 30, 40 years, you know, laws change, and so they may require something different. I have had that where a bank won't recognize a power of attorney because it's too old, which, you know, maybe their legal department decided they wanted to work for their money that day, but no offense to any bank attorneys, but you know, I think in general, a power of attorney is going to last until it's revoked or amended.
I have just one other kind of question or area to ask you guys about. It's only because my husband does work in kind of the big data world, and he was mentioning that he believes at 18, if you have a credit monitoring service at 18, your child would kind of roll off being monitored under that for identity theft and fraud. Do you all know, do you work in that area at all? Is that something that at 18, they would need their own, you know, if you're paying for an annual identity fraud service, that your 18-year-old would have to roll, you know, have their own as well? I
don't know the answer to that question. I think it would probably be more under the terms and conditions of the agreement with a credit monitoring service. My guess is I can see why they might roll off, because technically you wouldn't be entitled to that information. Like, you couldn't order a credit report for your child who's over the age of 18 unless they, you know, gave you authority to do that somehow. So I can see why they might. I just don't know the specific answer to that question.
Okay. Okay.
All right. Thank you so much, ladies. Thank you to everybody who joined us. And we can all wish that our kids would stay 17 forever, but not the case. So thank you.
Thank you.
Stay safe.
Right, thanks very much.
Happy Zooming.
Thanks.
Thanks.